Welcome, everybody, and thank you for joining us this afternoon. This is Von Doan with Haley Tamarillo, and I'm assuming you're here to learn about what has been happening in the world of SIDGE in the last year. Um, just so you know, we do know that it's going to be very difficult to get through all of our slides in the allotted 1 hour. Unfortunately, I have another webinar I have to join at 2 or no, at 1 o'clock. I'll be late for that one. But in case you have all the materials, you have all the cases, so we might be flying through the cases and talking more about the practical procedural issues that you may be facing in Maryland courts. Like I said, with me today, I have Haley Tamburello. We don't have an official bio. All you need to know is that she really knows her stuff, and she wouldn't be here otherwise because we always invite only the best and the brightest for our MSBA members. So with that, Haley.
All right, thank you. So I think we're ready for the first slide. So next. All right, we're going to breeze through some of these, like Fawn said, so that we can get to discussing SIDGE in a COVID world as well. But this was a case, matter of AOC. It was an appealed case through USCIS that happened because in Massachusetts, they did not have a state law like Maryland did that permitted SIDGE until 21. And so the court still issued the predicate order after the child had turned 20 years old. But Massachusetts changed their state law while the NOID response was pending. And so the child ended up qualifying as a child under Massachusetts state law while the I-360 was being adjudicated or was being responded to. So next slide. And the main takeaway is that USCIS was very concerned about whether or not the court had jurisdiction in Massachusetts to hear the case. And so a theme that we're going to have today is to make sure that you have very detailed orders that have all the information that USCIS is looking for. And one of the things that they're looking for is clarity that Maryland is acting under its authority. So make sure you cite the Maryland code to show that they have jurisdiction over your client. Next slide. All right. This is another case out of Texas where it was similar to a SINA case here in Maryland, but in Texas, the child was taken out of the family home, placed into protective custody, and there were a variety of hearings that took place in the Texas court that discussed reunification of the child. But at the end of the day, the judge in Texas issued a predicate order for SIDGE that just copied and pasted the INA statute. Reunification with one or both of her parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law. So there were no facts in the order that explained which parent or which ground qualified the child for SIDGE, and that is what gave them trouble with USCIS. So next slide. And at the end of the day, two things that are important to know out of this case. One is that USCIS eventually looked at the situation under the totality of the circumstances, and they looked at all the different orders that came out throughout this child's dependency case and found out that actually, the judge did in fact make all those findings, even if they weren't written clearly in one sheet of paper. The other interesting thing about this particular case is that it was USCIS denied the I-360 because the attorney filed a late response to the notice of intent to deny. The attorney explained that the response was late because they were waiting on orders from the Texas court and it was kind of out of the attorney's control. And at the end of the day, they accepted it late. So obviously, do everything you possibly can to get your responses submitted timely, but know that if something happens that's out of your control, don't just throw your hands up and give up because they are still considering seems to be extreme situations. So next slide. All right. And you could read this yourself, but again, just try to make sure that you have as clear of orders as you can the first time. Make sure if you have a Senate case that you're working with the Senate attorney or the judge, because sometimes they prepare the orders and not you. So they might not be as familiar with USCIS requirements. And one other thing to note is that USCIS, one other way to say that they're looking to make sure that you are not just filing these cases for SIDG classification, but that you're looking for relief from parental mistreatment. So make sure that in your pleadings with the court, you're clear that the child needs protection. If it's in the case of a custody or guardianship case, then we're looking for protection from the bad parent, and the protection is by giving custody or guardianship to the safe, responsible adult. So,
So,
oh, I'm sorry.
Haley, we went through a period of time early in the SIDG when people were just getting a handle on SIDG, that we went through a time when we could use like these, template orders that cited to the INA, and then there was the issue when USCIS started asking for more these more specific orders. So even during this time when USCIS seems to change what they want, it changes, from month to month or
Right.
year to year. So what happens? How do you get an order changed, or amended in state court to meet whatever it is that USCIS has decided that they want now?
Yeah, I mean, I definitely agree with you. It's hard to anticipate all the possible ways your case can get RFE'd, and the ways that cases are getting RFE'd today might not be the same ways they get RFE'd 6 months from now. So it's impossible to really have a completely perfect order that is going to make USCIS happy at any point in time. But if you come up upon a situation where your order is not sufficient, the best thing to do is contact the clerk of for that specific judge that issued the order and see how they prefer you to request the change in the order, because it could be a simple issue of you resubmitting an order and them signing a new order. It could be a more complicated situation where you have to file a motion to reopen the case and a motion to amend an order, and it's really a judge specific situation, and you'll save yourself a lot of time and grief if you know what that particular judge is looking for. And I think most judges are pretty willing, if they're granting the SIDG cases in the first place, I think they're probably pretty willing to make changes if need be. You might have to be really pressing with the time constraints too. We only have X amount of days to respond. What's the quickest way we can push this through? But definitely speaking to the judge's clerk is probably your best bet. I mean, what do you think? Do you have any?
Oh no, I agree completely that you want to go to the judge who made the decision, the initial decision, and sometimes depends on the which bench we're talking about. Some are friendlier than others, because we had a situation in Howard County recently where the child was adopted and they didn't request the SIDG filings initially. So then the attorney went in to file to reopen the case, um, with the judge who actually granted the adoption. And he said, no, that case is closed. We didn't talk about this. If you want to, you need to just file a motion for SIDG findings, and you can do that because the court still has jurisdiction. And believe it or not, that case was actually then appealed to the Court of Special Appeals, who had to make a finding of whether or not there was, because the judge who actually then the funny thing was, so the attorney did what the judge said, which was to file the motion. And another judge looked at the motion for SIDG and said, no, you need to reopen the case because otherwise you have res judicata. So the attorney's like left between two judges on the same bench telling them one to do the other, and no one really wanting to touch this. And it went to the Court of Special Appeals, and the finding was that no, you don't have, they don't have to reopen the adoption, just file the motion for SIDG filings under that case. And so it really does start with the judge who did the initial, but you might get bounced around a little. And it's up to you to, be convincing. And hopefully the second judge, if you get bounced from the initial one, you'll get the second one who just says, just file the motion for SIDG. The only problem may be that you may have to nunc pro tunc it. And in order to nunc pro tunc, you have to have a clerical error or something from the initial order. And that might be, and I've used this in situations where people didn't file the motion for SIDG initially, which was to find, if you do the adoption, usually when you have an adoption, there's a reason for the adoption, and hopefully those facts of, findings of facts were made in the order for the adoption, or at least there's a transcript that can be now transcribed to make those findings nunc pro tunc. So it can get tricky.
Yeah, I mean, I had a adoption case a couple years back in Baltimore County, and we were able to reopen for clerical error and made SIDG findings, and it
Mhm.
ended up being fine. The client was not from a Central American country and was able to get their green card and everything.
Right,
So it worked just fine. It's just a matter of logistically getting in front of a judge.
right.
So let's do the next slide. Okay, so this is another Massachusetts case. These four bullets are in whole the predicate order that was presented to USCIS. So the court has jurisdiction over the petitioner. The petitioner is under the court's jurisdiction until 21. Due to abandonment, reunification with the mother is not viable, and it's in the best interest of the child to remain in the US. So, next slide. And I'm sure this is not really surprising that the issue here was the sufficiency of the order. But the big thing that you might have known that was missing was that there was no placement of the child. It's not we're placing the child in the custody of a particular person or guardianship of a person, or the child is remaining in the dependency of the state. There was nothing about where the child is going. It was just a statement that the child is SIDG eligible. So obviously they received a lot of pushback to that, and that was it was a huge issue for them in the case. So next slide. Um, I bring this up. I know this case is from Massachusetts, and that you might be presenting great predicate orders in your own state court, but every now and then you might get a client who comes to see you, or a prospective client that comes to see you and says, "Hey, I already have a pending I-360. It was filed in another state." And I had this personally about a year ago. I know that some of the judges in Texas were making SIDG findings for children that were in ORR shelters before they reunited with family. And some of the nonprofits in Texas were filing I-360s on the children's behalf, in part to get them out of ORR shelters and to kind of move their case through immigration quicker. But the Texas judges were not placing the children with anyone either. They were just saying, oh, the child's in an ORR shelter and the child is eligible for SIDG. And those cases, X amount of months later, a year later, are ultimately getting denied by USCIS. So if you have an 18-year-old or a 19-year-old or a 20-year-old that comes to you and says, I have a pending I-360 that was filed in another state, see if you could get a hold of the predicate order, and then use a judgment call. Take advantage of what time you may have. And if you have to refile in state court in Maryland, that might be the case. But you don't want to be in a situation where someone hands you an I-360 receipt, turns 21 before the I-360 is adjudicated, and the I-360 is denied, and you could have had an opportunity to apply again, but in Maryland. So just be aware if people come to see you that have these pending I-360s, that not everyone has created as perfect of a predicate order as you might.
And so, Haley, how do you make sure that you have the ideal predicate order when you come to court?
So you want to make sure that you're asking for the placement of the child. You want to make sure that you have citations to state law, what gives the court jurisdiction to make these findings. I like to include what the statute is to define abuse, abandonment, or neglect, and then some facts in there. So not just saying, oh, the child was abandoned by mom, but rather the mom left the family home when the child was 3 years old. The child has had no contact with mom since that time. The mom has not sent any financial support to the child's caretakers. The mom has not called and inquired about the child's well being. As long as you put I mean, I put about a paragraph or two of information in. You don't need to write a whole book for an order, but as long as you put some facts besides just a blanket statement of the child was abandoned, then I think that generally that looks decent enough to get an approval.
And so you are actually drafting a proposed order for the court to consider, right?
Yes. So I'm drafting the proposed order. Every now and then I have a judge that says, "Oh, I'd like to also include an extra sentence." So maybe something came out in testimony that hadn't necessarily come out when we were preparing the orders months prior. Or maybe I've had a couple times where the judges wanted to include citations to recent case law at the bottom as almost like a footnote to the order. That's fine. If they want to add to the order, that's not a problem for the most part. If they want to add the INA sections to the order, that is a different situation. And I push back on that because USCIS gets a little upset if they think that the state court judges are interpreting their provisions of law. So I try to explain, I understand the bench thinks they're being helpful in this by adding the INA citations, but actually it's probably going to cause a bit of a problem. And I'm probably going to have to come back here and ask for a revised order. Do you think we could leave those out? And generally they're fine. I honestly haven't had an issue with INA citations in a while. So I think most judges that are doing SIDG cases right now are on the same page with that.
And when the judge offers to, make those changes, my sort of practice tip is if they're offering to make the changes, if they're not handwriting it in so you can't get the order right away, I generally offer and say, Your Honor, would you like me to make those changes? And can I have the email address to send it to your law clerk? And they're more than happy to do that. And if I put the onus on me to get the order to them, that just, first of all, I get to control what my draft order still looks like. And I know exactly what's in there. And secondly, it usually expedites the process. And I can follow up with the law clerk and say, Did you receive it? Good. Can you have it on her desk or his desk by, and signed by the end of the day? I'd really appreciate it. I can stop by and pick it up, et cetera, et cetera. But it's, as you'll learn throughout this entire, or you'll hear from Haley and myself, it's follow up is key. And so that allows me, it gives me an in with the law clerk too to say, hey, and is there anything else you want me to do? So the more you can do for the court, the better, the more likely it is you'll get what you want when you want it.
Definitely. I definitely agree. Whatever makes you a more helpful to the bench type of attorney will only result in better things for your cases. All right, let's see. So I think we can go to the next slide.
All right, so Haley gets a break and she gets to ask me the questions, maybe, that I may or may not have answers to. But this is a really long read, and hopefully, all of you should have received a copy of both the handout for the presentation along with a copy of all the cases that have been mentioned in the presentation. So Perez versus Cuccinelli is a great case, and it again makes me feel very grateful that we're in the Fourth Circuit. But if you have the time, I definitely believe it's worth the read because there's a great discussion on statutory construction, and it talks a lot about what we always tell our attorneys in the SIDS trainings, which is that the regulations are out of date. They don't reflect the current statute. The USCIS policy manual is just that. It's a manual, it's for guidance, it's not law, and it's definitely, can be rebutted and argued. And that's what this case is all about, is how an agency has interpreted the statute and why it shouldn't be given any deference. So when you have a chance, and the wonderful thing about this particular case is that there's also this lengthy dissent, which we're not surprised about, but it gives you insight into how the other side is thinking as well. So when you get the chance and have a lot of time, I think this is a 40+ page decision, give it a good read. It should take you at least a couple of evenings. Anyways, so in Perez versus Cuccinelli, we had a brother who was granted temporary custody of his 18-year-old brother. And before the younger brother, turned 18, they were able to get the temporary custody. And in the temporary custody order, they refer to a future permanent custody hearing. But of course, for whatever reason, it was not, put on a fast track. The hearing never happened, and so there was no permanent custody entered. And if for those of you who are listening in and are aware, the USCIS policy manual, which came out to interpret their outdated regs, had made it very clear that they did not consider temporary custody or guardianship, temporary orders of any kind, to be legitimate forcage purposes. So, of course, USCIS denies based on that, there was only a temporary finding and there's no permanent finding that reunification with either parent was not viable permanently. They appeal, of course, it's upheld. It goes to the Western District of North Carolina. They also affirm the decision of the agency. Now, again, because we're in Maryland, we have it easy thanks to work done by a lot of other people that we have until 21. But in North Carolina, it's the age majority is 18. So that's why this became an issue. Next, please. So you can read the long version of the question as posed by the court. My version of this question is underneath, which is basically, does reunification, non-viability of reunification, have to be permanent? Meaning that these parents can never, the bad actor parent can never be reunified with the child ever, 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 and therefore, by default, by inference, does the custody order then have to also be permanent? Next. And the court definitively says no. Look to the plain language of the statute. There is nothing in the statute, both by word choice and omitting certain words. If you look at the context of the entire statute, there's nothing that says that this has to be more than a couple of days, months, weeks. And you look at here it cited reunification with one or both of the SIDGE applicant's parents is not viable. They chose the word is. And the court interpreted that to say presently non-viable, not forever, not permanent or everlasting. And then they go on to talk about the word custody and the definition of custody. And they talk about how it's traditionally, it can be either granted for a number of days, months, or years, temporary or permanent. And so you never get into agency deference because the statute is clear and unambiguous. And then they also, just to put the nail in the coffin, they're like, by the way, USCIS, you are now interfering or trespassing or on state court authority, because traditionally custody determinations and family matters have always been a question of state law. So you're out of your territory here. Next. So basically, they don't require, the court's saying, nope, there is no permanent custody order required. We're not going to give you Chevron deference or Skidmore deference. You've done everything to defy the plain statute of the language of the statute, and you impermissibly intruded onto state domestic relations law. So not only, did you interpret it wrong, this is not your place. So
So let me ask you a question about this. Can you think of a situation in Maryland where getting an ex parte temporary custody order is helpful to
we
practitioners?
actually did. Early on, we did. And they were being accepted. And we did. I'll tell you, I had hearings. I had sent in pretty much like 3 days. I got a lot of stuff from, the charities saying, Vaughn, we really need this order. Oh, how much time do I have? 3 days. I'm like, oh. So I would run down to Montgomery County. Thank goodness the case was in Montgomery County. And so this is my like Guinness World Record that I got this case. I got the order in 3 days because we would file an ex parte emergency based on the circumstances that the child would lose out on these benefits, that they would be irreparably harmed, and it was not in the best interest of the child, and stated all the reasons why. And this was back when the age in Maryland was still 18, and they would walk it through. And we had a specific judge who was very sympathetic and understood the circumstances, and she would hear these cases like on a Friday afternoon, really extended herself to this cause. And the ex parte temporary custody order would go through, and Sige was approved at the time. And this was pre the USCIS policy manual, though. But I'm sure, and there was always this issue about whether or not the court had continuing jurisdiction, right? Because the child aged out in 3 days, like literally get the order, and we would walk the order through, get a copy, and file the I-360 the next day. So
Do you think it's
does
going to become
Perez does Perez Cuccinelli open up that possibility? I think you definitely have an argument for that. The question will be, and this is why I find it interesting that the way this case that they said, that you intrude into the issues of state domestic relations law. We always knew, and USCIS has always said that they can't look behind the state court order, right? But then they come out with at the AO decision saying that people, they do have the right to determine whether or not you went to get relief really as a matter of, you know, to save the child or for immigration relief, right? And at this point, you're saying, I went to court 3 days before the child ages out, before 21, but technically the court's jurisdiction ends in 2 days. So what's the purpose, right? Um, but if we claim and we allege that a lot of these kids age out, but they really aren't, they're not mentally and physically able to really take care of themselves, to make the decisions that they need to. And that's why we go into court, to give these parents or, guardians the right to or the ability to make decisions on their behalf so that healthcare providers can share information, that they can still continue to, for instance, get health care, etc. So I think if I had to, I would still try it, yes,
okay? Great.
but I would try almost anything. So next. All right, another great decision, and this is, I say Perez versus Cuccinelli is the gift that keeps on giving, because right after the decision by the Fourth Circuit, this is a case that comes out of the district court in South Carolina. And it's interesting because I think in this situation, USCIS and counsel for the government really screwed up, like didn't understand family law at all, or somebody forgot to read the state code. Because this was actually on its face seems much clearer than Cuccinelli or Perez versus Cuccinelli. So again, we have another temporary order, but in this case, mom gets denied and says, okay, I will go back to state court and I'll get a permanent continuing custody order for maintenance and support, recognizing that this child had already turned 18. But in South Carolina, even though the age majority is 18, there's an exception, just like in Maryland, where if the child is still unmarried and still in school, then that child is still considered a child, and it's clearly stated as, as part of the law. It's not something that was made up as part of case law. It's in the statute. In any case, she gets this order and she refiles for Sige. And once again, US denies, because in this case, it's not because, so now you've fixed it by getting a permanent order, but they're saying the court didn't have jurisdiction because this was no longer a child under South Carolina law. Next. And so the question they pose is, do you really even have to be a child under state law under the age of 18? And we go through the whole statutory, and you can read this. This is a shorter decision, only 18 pages, I believe, but it's worth a read, because if for those of you, if you haven't been practicing Sige since the beginning, since its inception, this is a really good case to read, because it actually goes through the evolution of Sige and how, it has evolved over the years, but because how it's changed, and why you can see the congressional intent through the change in the statutory language, and how the regs haven't kept up to reflect that, and how in their own way they're saying, USCIS, you knew because you were told by the ombudsman that your regs no longer reflect the current statute. You said that you would update them. You never did. And in fact, you came out with a policy manual instead. So, eh, nix on that. We're not going to give you, there's no, again, they said no Chevron deference because it's clear and unambiguous, and no Skidmore deference because you give no reason why, any reasoning or any analysis for your conclusion, either in the policy manual or in this case. So, next. And so they said, you know what? Looking at the language that's used in the statute, they talk about a dependent. They define the word dependent. And again, no mention of age, no number, only refers to, a person. There's no someone who's dependent on someone else for support, not able to exist or sustain oneself, which is what we claim when we, get these older kids in, right? That they really don't have the mentality, they haven't been in school, that they really are technically and mentally still a child and need an adult to support them. And on top of that, there's no reference that this person even has to be deemed a child by state law. And they talk about the omission, that you don't ever see the word child used in SIDG in the current statute at all. So not necessary. Next. And they go on to, even though they could stop the analysis there, they go on to say, by the way, even if we were to accept your first position that this child had to be a child under state law, you clearly didn't, look at your state law because um, the South Carolina order, and this is really a good, again, um, look at how you should construct an order. The temporary order specifically retained jurisdiction over this child until a final order was entered, stated that clearly, and the final order then referred back to the temporary order to continue extension of the court's jurisdiction. And the final order was very specific in saying that we are not only doing, uh, this custody, care, and financial, we're doing all of this. This child is dependent on the court, and we are addressing custody, care, and financial support. And the reason why they did this was there's a case out of the Fifth Circuit where a case was brought into family court. And I say, quote, family court, because in Texas, apparently all the courts have, just like in Maryland, have equity and jurisdiction. We don't have a specific juvenile court per se. So, but in that case, it was brought as a child support matter. And the Fifth Circuit said, nope, this is clearly child support. There was no placement of the child per se. No custody issues were addressed. Therefore, this is not a dependency order, and it doesn't qualify as a SIDG predicate for purposes of filing the I-360, and the child is not eligible for SIDG. So that's how they distinguish it from the Fifth Circuit case. So, but if you have time, like I said, definitely a case that's an easy read and worth reading. Next. All right, so this is one of our very own cases, and just to go through, this is a very easy case to read as well, but very strange to me how or why this judge thought this, but the burden of proof has never been stated in terms of SIDG findings. And in this case, the circuit court admitted that they didn't know whether or not it should have been a clear and convincing or by a preponderance of the evidence, and ended up saying, well, even if it was by a preponderance of the evidence, it wasn't enough. And so even though the judge granted custody to dad, they declined to make the SIDG findings. And I think the judge was put more on a hot seat in this case, because there was opposing counsel. In a lot of our cases, there isn't an opposing party. In this case, mom, who was in Guatemala, did hire counsel here in Maryland and contested. So I think that's why this issue came up at all. Because in most cases, I would have assumed, and I think most of us would have assumed, that this is a civil matter, another family law matter. So by default in Maryland, it's by a preponderance of the evidence. Anyway, so it goes up to the Court of Special Appeals. They affirm the lower court's decision that even if it was under that, they believe that it was a preponderance of the evidence, and even under that lower standard, that you didn't have sufficient evidence, even though none of it was uncontroverted. There was no countering testimony in this case. Um, so you're wondering why mom would have hired counsel, because you guys realize that when you file for SIDGE, it cuts off that tie between child and parent for future possible immigration purposes. It's for both parents, just in case you forgot. So that might be the reason. I've also had other parents who were reluctant, opposing parties who were reluctant, and we can talk about that. But go on to the next slide, please. So, like I said, the takeaway from Perez is that in order to make SIDGE findings, you just have to prove it by a preponderance of the evidence. Next slide. And more importantly, that when you do look at the evidence, the court must evaluate this based on a totality of the circumstances and determine, broadly speaking, if whether or not the prior parental mistreatment precludes a workable reunification. So it it doesn't just say that at that moment. You're looking at the big picture and the history of this relationship, in terms of making that determination. So I have you ever had opposing counsel or party, Haley, who didn't want to cooperate? And
No, I mean, I've had defendants who wouldn't sign a consent, but that's as far as I've gotten in terms of pushback. I really haven't seen a ton of cases where there's an active dependent or defender rather.
Mhm. I've actually had two cases. One was because mom had asked for child support, so I had to talk to mom, who I was representing, to say, this is really not the time to ask for it, because we were running up against, again, a timeline for at least one of the three kids, and dad was hiding away in North Carolina with another family who was totally unaware that he's had another family in the US. So it's another one of my interesting family law cases. But um, so you as the attorney, it's your job to, and you got to be careful though, because a lot of times the other parent, the one who's alleged to have committed the abuse, abandonment, or neglect, um, is not represented. So if you are talking to a pro se party, you have to make it very clear that you represent, someone else, and that you don't have their best interests at heart. And I make it a habit to only communicate via email, because then it's documented, and I always put this nice big line that says, please consult independent counsel. I always start with, dear sir, so and so, on behalf of your wife, she has retained, me to represent her in this matter. So it's very clear who I represent. And otherwise, you might find yourself in a situation where someone's going to try to rescind the order that you just got based on a misrepresentation, or he said, she said, this is what they told me, this is why I did it. But it is all these cases, when we had an opposing party or someone was reluctant, I was able to work it out so that we eventually got to a solution that worked for everybody, and everybody understood what was at stake or why we were doing this, and if it was the right thing. I mean, because the allegations still have to be true. You can't, claim abuse, abandonment, and neglect just for SIDGE. It's got to be true. Um, and the other case I had was an adoption matter. That was a little bit trickier, because I actually was called in by the court to represent the kids in that case, not the petitioner. So, but in any case, just realize that you may have opposing parties, you may have opposing counsel, just know the law. Next. All right, Haley, they come knocking.
All right. So, and this is honestly goes hand in hand with our upcoming discussion about practicing SIDGE during the COVID-19 crisis, because honestly, the only SIDGE cases that are happening right now are emergency hearings. So, the first thing you have to do is analyze how urgent is your case, and recognize that there's a huge difference between someone who is turning 21 in 6 months versus someone who's turning 21 in a week. So, how much time you have is going to determine how you label your requests. And also finding out from the court how long it's taking them to schedule cases. Because if you have a case that the court says, oh, we're scheduling cases 2 months out, and the child's not turning 21 for 8 more months, well, it's not an emergency at all. It's just normal processing. But if you find out that, oh, our next scheduled hearings are 5 months out and your kid is turning 21 in 3 months, well, you have to make some extra steps to be able to accomplish your case. So the first step is really to figure out how fast the court is moving and how much time do you have before your client turns 21. Um, Labeling a case as an emergency hearing request or an expedited hearing request is definitely jurisdiction dependent. Von, you had mentioned to me the other day that certain courts were, I think you had said Anne Arundel County maybe was asking for expedited labeling if the cases were a certain period out. Do you want to talk about that a little bit?
Yeah, a lot of us who, I mean, some of you, I see the list of attendees, so I can tell. But if you practice family law or do any state work, you know that we've had a whole bunch of webinars, and a lot of them have been, jurisdictional specific. And so, what I can tell you from having sat in on a lot of these is that Anne Arundel County, even Baltimore City, and Prince George's is iffy because it really depends on who's sitting that day. But it, at least in Anne Arundel County and Baltimore City, they would really appreciate it if you choose wisely. And in Anne Arundel County, I would strongly suggest you to choose even more wisely because, unlike Baltimore City, who may like move you over to the right track, Anne Arundel County will just deny. So if you file for an emergency as an MDEC and then you walk it in like you're supposed to, and it's not really an emergency, you just lost it. They're just going to deny, and then you're going to be sent back, and you just wasted some time and your client's money. And so, what they're saying is that in Anne Arundel County, if you are looking at anything 3 to 4 weeks out beyond that, ask for an expedited hearing. And what they're trying to do in Anne Arundel County is they're looking at their calendars and they're basing it. And if you ask for an expedited hearing, what they're doing is they're looking at their calendar based on when the court's supposed to reopen, and they're actually setting cases in for the hearing. So, unfortunately, you guys all know that by now the court has extended that closure date. So, Anne Arundel, for all their efforts, they've set in these hearings after the first one was in May, so those will all have to be reset as well. But the point is that they are working on and they will schedule the expedited hearing. So if, let's say you have a kid who's going to age out by June, 25th or something, that's not an emergency. File that initially, put in a motion for an expedited hearing, and because the court's supposed to reopen June 5th, they'll try to set it in before. If you tell them you need a week, to send it out and file the I-360, they might get it in closer to right after the court reopens, or at least well before that date. And the magistrate and Judge Schaefer, Magistrate Turtle, said in this webinar conference that they will, it's better for you to file the expedited and then follow up with the emergency, because now you have due diligence. You've alerted the court, you did what you're supposed to, you waited. But let's say what happens, later this year is what happened just now, which was the court extends that closure. So now you have a sympathetic ear because you did what you were supposed to. Baltimore City said the same thing. Please do not label things as emergencies, but they're a little bit more lenient. They might just say, okay, you really are asking for an expedite, and they'll do it on their own, whereas Anne Arundel County would just downright deny you.
And I can tell you that Baltimore County, I had a hearing there on Monday, and the other emergency case that went forward on Monday was aging out in mid June. And Baltimore County scheduled and heard that case as an emergency matter. So
Okay.
everyone's doing it slightly differently.
Right. But so the quick trick is to call up the the clerk's
Yeah.
office. Yep.
Yeah, and honestly, it might if you could get an email at this point, I think maybe email might be better because I don't know if
Mhm.
all the clerks are going in every day,
No.
whereas it seems to be that they're checking their emails frequently.
Mhm.
So I guess let's go next slide. All right. Um, if you have to request an emergency hearing, see if you could get consent from all the parties. You will be infinitely in a better position or a more convincing position if it's an uncontested case. And sometimes you get a little bit of pushback on your client, like, no, I do not know where defendant lives, haven't heard from defendant in a decade. And if you just accept that as fact, then you're going to have a harder sell to either file a motion for alternate service or to be in a situation where you could have gotten a consent but you didn't. So sometimes it takes a little extra time. Like if you have to give yourself an extra week for them to locate a defendant and get a signature on a consent, you're in a way better situation long term to file your emergency motion. So I always make a huge push in cases of children turning 21 to see if they could find the defendant and if the defendant would consent. The procedure for requesting an emergency hearing very, very different depending on what your state court is, and now incredibly different depending on what your state court's or COVID procedures are. So find out from the court clerks how they are handling emergency motions currently. Baltimore County will accept them through MDEC. Uh, I believe there's a drop box in Baltimore City to hand deliver it. I'm not entirely sure, but
I
do you
know,
know how they're
Prince
accepting it in
George's.
Randolph?
Yeah. Prince
Is it
George's and Montgomery County definitely have drop boxes.
Yeah. So you just need to figure out what your particular county requirement is. Next slide. All right. Um, Make sure you serve all parties your motion for an expedited hearing or an emergency hearing. Sometimes, if you are able to get the defendant's email address or fax number, you can show, look, I'm making a good faith attempt to serve them because it's going to take over 2 weeks for them to receive mail in a foreign country, and we're asking for a hearing next week. So here's the proof that I notified everyone. Also, logistically, figure out how much time you need to do the case in terms of days. When is the child's birthday versus what day of the week is that? When are courts closed? When can you get things sent out in the mail? Right now, especially because of everything going on, a lot of mail service providers are having limited delivery. So you might have been able to assume timely next day delivery in the past, but don't take that for granted right now. So give yourself extra time, but then you also have to be a little flexible. If the court only has one possible day to squeeze you in, you got to take the day. But the biggest thing is follow up with the clerks as much as humanly possible. They're the ones that are going to get your hearing scheduled, and you want to make sure that your case isn't just stuck in a large stack of papers on someone's desk.
Yep.
Let's say Tim
You
Davis.
want to mention the assignment office, Haley, quickly?
Yeah. Tim says, seems like Montgomery County is scheduling video hearings where children are aging out between May and I'm guessing junior writing. That's great that Montgomery County is doing that. I wish Baltimore County
Hmm.
would do video hearings. Um, I'm sorry, Mom. What did you ask me to say
Did you
before?
want to mention the assignment office?
Oh, yeah. So if I know that in Baltimore County, the assignment office isn't taking phone calls, so you have to go through the clerk for that. But otherwise, you might be able to call the assignments office and find out when they're scheduling their
Yeah.
hearings. It's everything is so up in the air right now with COVID. It's really just a matter of calling every possible person, seeing who answers, seeing who responds to an email, seeing what they know, and seeing when you could get your hearing scheduled.
Yeah, and you should know, I would say as a general rule, if you are going to file manually or even in MDEC counties, you need to follow, if you are going to make sure because Montgomery County and Prince George's County have made it very clear that if you have an emergency, you need to put it on their envelope. If you're using that drop box, use, put in, just like we do when we send things to VSC, the Vermont Service Center, right? For supervisor only. Well, in this case, emergency must be read by or open, today, because those, even though the court has asked people not to file anything that's unnecessary, people are still going to file them, and that's what they're finding in their drop boxes. But if you put the emergency motion on that envelope, they will open that first, and they will follow up. And Montgomery County is very good about that, and they're trying to do everything they can remotely. I'm really surprised about Baltimore County, but I think a lot of it has to do with, like I told Haley, every individual judge's comfort level with the technology and who's appearing before them and who's on the other end of that phone. So,
So
but
we have a question, Prince George's County, any tips with getting emergency hearings scheduled right now? I think my game plan, if I have a court where I need to get a case scheduled, is I'm calling everybody. I'm calling all the judges' clerks. I'm calling assignments. I'm calling the head clerk's office. I'm sending emails. You have to find someone who answers the phone and just really push that it's an emergency issue. I mean, the Chief Judge Barbera's orders say that SIDGE counts as an emergency that can be scheduled. So even if you have to include a copy of that in your motion, I don't know what other tips you have for Prince George's County.
no, that's actually true, and you should be able to, get that in as long as it says emergency motion on it. You do just Prince George's is just the biggest headache for me, so I try to stay away. But um, they have a judge who's doing SIDGE right now, and they do have a judge who's looking at these emergency motions and should be followed up. So you do have to follow up with the clerk's office to make sure. I know I've spent literally, hours on the phone with PG County clerks to wait for them to walk something over and confirm. So um, that's how I deal with Prince George's County.
The
But
follow-up,
right now, actually,
if
I
it's
hear
not
they're
an
pretty good
emergency
because of
in
the
Prince
envelope
George's
labeling.
County. So the follow-up question is, if it's not an emergency in Prince George's County, I think honestly in any of your SIDGE cases right now, if they're not emergencies, it's not worth aggravating the court over.
No.
So unfortunately for you and your client, I just think that you have to sit tight and wait if they're not in a situation where there's an actual age out emergency or other type of emergency.
And because you've already got it filed, you can still follow up and file an emergency motion based on the fact that this has been filed. But you can lay out all the facts. Like I said, that's the same approach that you would take with Anne Arundel County by going ahead and file a regular case with a motion for an expedited hearing. And then when you get closer, then you file the motion for the emergency hearing.
Yeah. All right, next slide.
All right, so the big question, custody or guardianship, as most of you know, there's a case called In re Zealand out there that really screwed up guardianship for Maryland. And even with people on the same bench in the same courthouse, some are saying yes to guardianship and others are saying no. I think Haley and I both agree that the safest bet is to go with custody whenever possible because of this sort of, you have a reported case from the Court of Special Appeals that says no guardianship unless parental rights have been terminated. But then in the background and what's really happening in the state of Maryland is that it just depends on where you are and who you're in front of. And just as an example, I've given you two unreported cases here from the Court of Special Appeals, one coming out 3 months right after the other and having completely different results. One's in front of in Frederick County, um, also for a child who's over 18 years old, and the Court of Special Appeals both say, nope, parental rights have not been terminated following Zealand. You can't do guardianship. The other case comes out of Anne Arundel County, and the Court of Special Appeals reverses and says, for other reasons, though, I have no idea what possessed this judge, but he pretty much said you can't be a guardian unless you're a blood relative, which we all know is completely crazy. But they do discuss, without saying the word Zealand, they talk about those factors, about why this case is different, about why this child being over 16 years old, and how the Estates and Trust article allow a child who's over 16 to petition for and appoint, and it suggests pick their own guardian even, and why, you know, even without the whole blood relative issue, that the guardianship should have been allowed. So here we have two cases, both from the Court of Special Appeals, different jurisdictions with different results. So what are we to do? Well, in a matter of WER, the judge pretty much told the attorney from the bench, said, don't you really think this is a third party custody case? Don't you think you should go towards custody? And my feeling is, when the judge tells you stuff like that, they're giving you hints from the bench. And if there isn't a time issue, or if you can't get it reset immediately, or you're up against the timeline, you really should follow the hints, because that's exactly what happened. He was telling you he was going to deny. And we also know that matter WER, the attorney tried to petition for a writ of cert, but that was denied as well. So there's no hope for some kind of reconciliation between, to reconcile what happened in Zealand and at least distinguish it for children over 16 even, or 18, under the Estates and Trusts Code. So here we are still left with, depends on where you are, but the key issue is on the next slide. But before we go there, I do want to mention, for those of you who are not familiar with standby guardianship, make sure you read up on it. It's something that was enacted for the purpose of, when everybody was afraid that Trump was going to deport anybody and everybody and just round them up, and kids would be left without care. We acted and asked the legislature to enact this standby guardianship that allows someone to go ahead and make plans to have a standby guardian if their parent was you couldn't access a parent because they were detained in a distant place or deported. Um, and that standby guardianship is important, because then that person has the right to make decisions regarding the child. And we made sure that, you'll see the footnote here, if you look at 13907, or the Estates and Trusts Code, you'll see that it specifically says that we don't have to terminate parental rights. And we are well aware of Title V of the Family Law article, and this is still consistent. So technically, I've had many conversations with different people, and I believe that if you are appointed as a standby guardian, you can file for SIDGE at that point when that standby guardianship is activated. Haley, custody.
Yeah.
Why are people so reluctant? Why do they like guardianship over custody? And
I think first of all, it sounds less extreme. I think that's part of it.
Mhm.
Also, if you're filing for third party custody, you have to show that there's either some type of parental unfitness or exceptional circumstances. It honestly doesn't bother me personally to file third party custody, because if I'm filing that I have SIDGE facts, I think I'll be able to show that a parent is unfit or that there's exceptional circumstances. So maybe one parent is unfit because they abandoned or neglected or abused the child, and the other parent either did the same or is unable to prevent that abuse, abandonment, or neglect. Um, but I personally don't think that it's that difficult to do third party custody in cases where you're already asking for SIDGE. That's just my opinion.
um, so I understand why people are reluctant, especially if you practice a lot of family law, but we don't have a whole lot of time other than to talk about my experiences, but to just say that at this point, because of the possibility of the Noids coming through, Zealand is the reported decision. So you are better off, if you can, to file for custody, so that you don't have to deal with the possible headache of a Noid down the road. Next. I have to get out of here really soon. So we're going to go ahead, Haley.
All right. Really quick, if both parents are deceased, best practices for a SIDGE case is to see if there's some type of bad act. Most judges are looking for either abuse, abandonment, or neglect prior to death. That is your safest bet to winning those cases. Sometimes you just don't have those facts. If you don't have those facts, you would have to make a constructive abandonment argument. very judge specific. But sometimes that's all you have, and so you have to do it. But if there is any type of SIDG factors prior to the death of one of those parents, that is most certainly the stronger argument.
So don't forget that because USCIS is doing this sort of, well, are you really in court to save the child, or are you here to get immigration relief? You also need to make that argument that the petitioner needs to, that this child needs the dependent to be, they are being supported or needs to be sustained or supported by somebody else. And usually the argument for that is, their inability. This is a new place, foreign to them. They don't speak the language. They can't make their own decisions. And of course, they can't financially support themselves. And healthcare, of course, is always, most judges like healthcare and keeping them in school kind of arguments. So next.
All right. My position is always admin close if it's an option. The reason for that is because you don't know what the policy priorities are going to be of the administration on any given day of the week. And so if your case is not on the active docket, your case is somewhat safer and insulated from changes of the administration, because you never know if we get in a situation where DHS says, oh, we really want to fight continuances for approved I-360s or continuances for pending I-360s. You don't want to get cornered in a situation where you have to file maybe a week 589 and end up with an individual hearing. So if it is possible to get an admin closure order, I would certainly go for it.
And I completely agree. And if you want to look at the factors, make sure in your motion to admin close, take a look at Romero v. Barr. All right. All right. I do not see any imminent questions at this time. I want to thank you, Haley, for joining us from Florida. It was a real pleasure. And I hope, people start emailing you instead of me.
Oh my
But she does a great job and does a great job of advocating for our children at the circuit court level, and adds a lot to sort of our knowledge base here in Maryland. So thanks
God.
again, Haley, for joining
Thank you.
us.
If
I'm
anyone has
glad.
other questions, feel free to send an email. I'm happy to respond.
Yep. All right. Thank you all. I am off to another webinar.
Good luck. Bye.
Bye.